Hello, welcome everyone to today's webinar called Your Legacy, Your Way, Busting Estate Planning Myths and Misconceptions. We're so glad that you have joined us today. So first of all, my name is Gunnar Kroll, Senior Charitable Estate Planning Advisor at the American Heart Association. And before we get started, I'm going to take a couple of minutes for some general housekeeping. But first, I want to thank you again for joining us for today and being a part of the association's second century. That's right, the American Heart Association turned 100 years old just last year. And thanks to many of our donors and volunteers that are with us today, the association has made a tremendous impact across the country and globally. Since the association was founded in 1924, deaths from cardiovascular disease have been cut in half. We have funded 15 Nobel Prize winners, funded more than $6.1 billion in research, and we train about 20 million people annually in CPR. These are just a few of the association's accomplishments over the past 100 years, made possible by the more than 32 million donors and volunteers that we have. We are grateful for the progress that we've made during our first century, and we are excited about the impact we will make over the next 100 years. So again, thank you for being here today and being a part of our history and being a part of our future. Before we dive into today's presentation, I've got a quick few housekeeping things I wanted to go over for you. First of all, it goes without saying that today's webinar is for informational purposes only and is not intended to provide any legal or tax advice. So please, please, please be sure to consult with your attorneys and financial advisors about your individual specific situation and your individual estate planning needs. So during today's webinar, you will have the option to control your own view. Simply use your mouse to drag the slide bar in the middle of your screen. If you're joining from a tablet or a smartphone, just pinch the screen to zoom in or out on the content. Feel free to go ahead and adjust your preferences now. While you do that, I'll point out a couple more of the webinar functions. Although we can't see or hear you, we do want to hear from you. So if you have questions, please use the Q&A feature on your screen to submit questions, and we'll answer questions as time allows during our presentation. Near that Q&A button, you also have the option to show captions during the presentation. To enable captions at any time during the presentation, simply click the Show Captions button on your screen. You may turn off captioning at any time by selecting Hide Captions. Now, let's get started. We have a great presentation for you today focusing on the myths and misconceptions in estate planning. Estate planning can sometimes feel like a complicated, challenging space to navigate. Whether you're just starting to think about your legacy or you've already taken steps to protect it, there's a surprising amount of misinformation out there that can lead to costly mistakes or missed opportunities. Today, we're going to explore some of the most common myths and misconceptions about estate planning. We'll clarify what's true, what's not, what you really need to know to make informed decisions about for yourself and for your loved ones. So I'm very excited to introduce today's presenters. With that said, our first presenter is Lindsay Weinberg. Lindsay is an estate planning attorney and partner at the Laderman Law Firm. Lindsay holds degrees in business administration and international studies from the University of Missouri, Columbia. She is a graduate of the St. Louis University School of Law, and Lindsay has focused her practice in the area of estate planning since 2015. She is a member of the National Network of Estate Planning Attorneys, a member of the Bar Association of Metropolitan St. Louis, and she is licensed to practice law in Missouri, Illinois, and Florida. Our next presenter is Andrew Fussner. Andrew is the Vice President of Estate Settlement for the American Heart Association. For the past 24 years, Andrew and his team have overseen the administration of bequest assets for the association. Prior to joining American Heart Association, Andrew was an attorney at a national law firm where he specialized in estate planning, probate, trust administration, and tax law. Andrew holds a law degree, a Bachelor of Science in Accounting, and a Bachelor of Arts in Political Science, all from the University of Florida. We're so grateful to have Lindsay and Andrew with us today to talk through this topic with us. So with that said, Andrew, I'll pass it over to you to get us started.
All right, great, Gunnar. Thank you very much. And thanks to everybody for attending today. And thanks for Lindsay for being our expert here on the call. So we're going to go ahead and I just jump right in. Like I said, we're going to cover 10 myths today, or try to cover 10 myths today about estate planning. And Lindsay and I will try to bust those myths that are out there. And that's the quick summary right there. But again, we'll be going through them one by one. So I'm going to move to our very first myth here. So common myth that we hear, Lindsay, is that you can use a will to avoid probate, or that you want to avoid probate. Why do you want to avoid probate, etc.? Is that a good thing or is it not? So bust this myth for us, would you, Lindsay?
Sure. Thank you, Andrew, and thank you all so much for having me today. So, given the choice, a lot of people generally understand that they'd prefer to avoid probate, but they just rarely have a full understanding as to why. So, let's break it down a little bit. There's actually two kinds of probate. There's probate for the living, and then probate for death. What happens to my assets when I pass away? So, let's start with probate for the living. Probate for the living deals with incapacity. So, gosh forbid you have an accident, an injury, an illness. You're not with it anymore. You're unable to manage your financial affairs. What happens? Well, generally, if you don't have a power of attorney, which we'll talk about, somebody needs to petition the probate court to be what's called your conservator, or some states refer to it as a guardianship as well, which is a court supervised process for the management of your financial affairs. And typically you need an attorney to set that up and to help you maintain it, because you need to petition the court for permission to spend funds for the incapacitated individual and convince the court it's in their best interest. Not to mention having to account to a court for every penny that's spent on the individual, and that continues until they get better or until they pass away. So let's transition to death probate, which is what more people are more familiar with. What happens to my assets when I pass away if they're in my name alone and have no beneficiary? So it can take anywhere from 9 months to a year and a half, if you're lucky, to complete the administration of a probate estate. I've certainly seen probates continue on for far longer than that. Generally, everything's public record. Creditors have the right to file claims. And guess what? Attorneys make a lot of money in probate. It can cost about 5 to 6% of the assets being administered, at least in Missouri and Illinois, and other states might have some different statutory fees for attorneys, as well as the personal representative or the executor who's administering the estate. So generally, attorneys make a lot of money in probate, but usually it's not what the family or individual had in mind. The bottom line here about probate is that it's really expensive. There's a lot of exposure, and there's several kinds of limitations. And at the end of the day, you're not calling the shots when things go through probate.
Thanks, Lindsay. And having a will itself won't actually avoid probate. You're still going in probate. You'd need a trust or something like that, right?
That's right. The last will and testament is a document that can only be administered through the probate court. And it only covers what happens to my assets if I pass away in my own name. They're in my own name and there's no beneficiary. So that's correct.
Gotcha. So probate in itself isn't necessarily bad. It just tends to cost more. And like you said, it's publicly exposed. And so a trust will help you avoid that, or beneficiary designations will help you avoid that. If you do have a trust administration, though, there might still be attorney's fees involved, right?
Oh, certainly. You're going to need an attorney's help generally if you have a trust or even if you have a will. So, of course, yeah, there's a cost for that. But that's exactly right what you said, Andrew. It's what's the definition of bad or good? It's whatever we decide it is. It may not be important to somebody, and a lot of people adopt the idea that, well, I don't care, I'll be gone. So that's one way of looking at it. Some people do care. Some people may not feel they have other options or people that they trust to actually be in charge of their assets and how they get to whoever they're supposed to get to.
Yeah, there's a lot
And
more accountability in probate, basically.
what was that?
There's a lot more accountability in probate, basically.
Absolutely.
Gotcha.
One quick question, Lindsay, that just popped in that is, I think that you all have already somewhat answered, but it is, how do I avoid probate court? Which if we're talking about litigation, that's a whole other separate question. So maybe just touch on that a little bit.
Sure. Well, like we said, the only place a will can be administered is through the probate court. So if you would like to avoid probate, look at setting up a kind of estate plan, which we'll touch on the other options today that allow you to say what happens to your assets and who they go to without court involvement. And Andrew had mentioned a trust or a revocable living trust, and that's one of the best options for accomplishing that.
And that leads us right into our second myth, which that is that beneficiary designations are enough. So beneficiary designations, like on your life insurance or your retirement assets, are one way to avoid probate, but it might not do the full trick. So Lindsay, you want to bust that myth for us?
That's right. So just real quick, what's a beneficiary designation? It's a designation that you put on each individual asset that you own that says where to whom it goes upon your death. And it's considered what we call a non-probate transfer, meaning it goes outside of the probate court. And examples of types and kinds of assets, like Andrew said, could be a life insurance policy, a bank account, an IRA, anything that you own at your death. And when you're setting these things up, one of the keys is that financial institution asking you to name a beneficiary. And if you're not, make sure you're thinking about that and putting something on file. Now, what can go wrong with beneficiary designations? They just say who the asset goes to, not how, and you can't really build in for what ifs or certain contingencies that happen. So I do have a few examples, and my friend Andrew is going to be my beneficiary on my bank account A that I own. So congrats, Andrew. So I have
I'm never going to collect though, because you're older than I am, and you're probably, I mean, I'm older than you are.
well, age isn't always a determinant for
True.
life to happen, which we'll talk about. So I have bank account A that goes to my friend Andrew upon my death. I pass away. Andrew survives me by 1 week, but he never claimed the assets. Guess what? They're legally his, but he never took title to them. So that's going to be probate for Andrew since he passed away. Next example, what if I have bank account A to my friend Andrew upon my death? I pass away, but unfortunately, Andrew was in a car accident and he became incapacitated. Without the proper things or documentation in place, now somebody needs to go set up that conservatorship for Andrew to manage those assets for him. Example 3, what if I have bank account A to my friend Andrew upon my death? I pass away, but Andrew died 2 days prior to my death. I didn't know about it, and so I didn't change my beneficiary. Well, what happens? That's probate for me because my beneficiary designation essentially failed. He was not living anymore. Example number 4, what if I have bank account A to my friend Andrew on my death? I pass away, and yes, good job, Andrew. You took possession of it. You transferred title in your name. But unfortunately, Andrew gets divorced the next day. Guess what? He's going to lose half of what's in that bank account, most likely. And my last example is my life insurance policy. If I name my minor child as my beneficiary, minors cannot inherit. And so when a minor is named as a beneficiary, somebody has to essentially set up that conservatorship through the probate court to manage those assets for that minor child. And that child generally gets it when they become an adult, which is, in my state anyway, 18 years old. Some states it could be 19 or 21. But again, that is dealing with the probate court in that case. So at the end of the day, life events happen. People don't necessarily die in the right order. And it's at least good to have something on file. If anything, sure, definitely have a beneficiary, but know that it's not always going to cover every possibility.
Great. So it's a tool. It can be a good tool. It can do a lot of good, and it does help avoid probate. But having perhaps a trust as a backstop to these could be very valuable for all those reasons that you went through. But it is a great. I will say this on behalf of the charity. An IRA in particular is a great gift to leave to a charity for various tax reasons that we won't get into at present. But let's move on to our third myth, which is that powers of attorney are enough. So a lot of times when people have an estate plan done, they also have a power of attorney, usually a financial power of attorney, maybe a health power of attorney done at the same time. So tell us a little bit about those, Lindsay, and what they do and what they don't do.
Sure. Well, you categorized it correctly. For purposes of our discussion, I usually look at the powers of attorney as financial or medical, and there can be various topics that a power of attorney is focused on, but we'll refer to those. So financial power of attorney, who do I name to be in charge of assets that are in my name alone, and they can do whatever I could do with them, okay? And then the medical power of attorney, who can make my medical decisions for me if I can't make them myself. So another aspect to know about powers of attorney real quick is that they can be what we call springing or immediate. Now, a springing power of attorney basically says this power of attorney springs to life when one or two physicians certify that I'm incapacitated and I can't manage my affairs anymore. An immediate power of attorney is exactly what it sounds like. It's immediately effective when it's signed. So the benefits of an immediate power of attorney can be, it eliminates that gap in time between when something might happen to you and somebody can start acting. And a springing power of attorney can be a little bit more protective just because we have those physicians who have to certify you're incapacitated first. So it's all about choices and what aligns with your goals. Now, the second question, what does it mean if a power of attorney is durable? Simply means that the document stays active even if you're incapacitated. And it just relates back to old common law that said any standard power of attorney automatically terminated if the person granting the power became incapacitated. So it's just to differentiate between the old kind of common law, and it avoids the probate court getting involved, everything working properly as it should. So that brings me to the pitfalls of relying solely on financial powers of attorney. Well, since we're talking about potentially granting a lot of power to another individual to act with regard to your assets, just as you could, you have to really trust the people that you name. That's a lot of power to put into somebody's hands, especially if you're saying they can access your bank account or they can change your beneficiary designations. It's very important to know what powers you're granting to someone. Not all powers of attorney are the same. Not all attorneys draft their documents the same way. So you really have to know what that document says. Another issue with powers of attorney is that they can be unreliable. There's no law that says anybody has to accept a power of attorney. And more, we're seeing financial institutions reject them for being too old. Now, how old is too old, you might ask? Well, it's whatever their policies say on that day. It could be 1 year, 3 year, 5 years. Those are just some examples. Some financial institutions won't even accept outside powers of attorney. So wherever you bank or have your investment accounts, it's a great idea to ask them if they accept outside powers of attorney, if they'll agree to put your power of attorney on file. Those are wonderful steps you can take ahead of time to make sure things are in order.
Yeah.
And then the
And
last
another
thing,
thing, oh,
oh,
sorry.
oh,
Another thing,
sorry,
Lindsay,
just,
that I would just say is that
yeah,
the other thing about a power of attorney is it ends the minute you pass away. So it doesn't distribute your assets at
right.
death, right?
That was exactly my last point, Andrew. Powers of attorney, we're on the same wavelength. Powers of attorney die when you die, just as Andrew said. So it does not give you a plan for what happens to my assets when I pass away. It's just a plan if you're incapacitated.
So again, it's a good tool to have. It can be helpful, but it's not the end all be all of everything for as far as setting up an estate plan. But it is an important part of it, that's for sure. And also, I think you made a great point. Make sure it's somebody you depend on. If you have, that nephew with a drug problem, he might not be the best choice to be your durable power of attorney. So, all right, so we've busted that myth. Let's move on to our fourth one here. Okay, estate planning is just for the wealthy. It's only those rich guys that are subject to estate taxes or that have millions or billions of dollars that need to set up an estate plan. That's a myth, right?
Absolutely. Let's look at who should have a plan. And really, when are we all considered legal adults in the eyes of the law? And in most states, you're going to see age 18. And actually, in looks like Alabama and Nebraska, they are age 19. And in the state of Mississippi, it looks like it's 21. And so, what's really a great place to start for anybody around that age is to have a financial power of attorney, a medical power of attorney, and a living will or advance directive. It might not make sense for someone at that point in time to have a trust. And it all just depends on, what's going on in their lives and what's important to them, what makes the most sense for them. So if you have nothing, those are wonderful documents to start with. And I just want to point out one really important thing. If you have a child who's going to college, a great thing to do is to make sure they have a medical power of attorney with HIPAA language and to put that on file with the campus health center. So gosh forbid, if there's an accident, you, the parent, can call and they will speak to you and let you know what's going on with your child. I've heard so many horror stories about that. So I always try to make that a point.
Yeah, I think that's a great point. And I think, it's also important if you do have one of those medical power of attorneys or healthcare surrogates for yourself, make sure your doctor has that as well. Give them a photocopy the next time that you go into the doctor's office. So,
Absolutely.
all right. So I think you've busted that one as well.
Real
It's
Right.
quick,
interesting because this
guys,
next.
sorry to interrupt. Can you repeat real quickly for one of the attendees what documents are best, um, specifically for the power of attorney?
Sure, like a medical power of attorney and a financial power of attorney and a living will or advance directive, which is the document that says if I'm terminally ill or a permanent vegetative state and there's no hope of recovery, that you wouldn't want to be hooked up to machines or be prolonged unnecessarily. If it's not going to make you better, it's just going to prolong your death. So that's an important one to have.
Yeah, and I think it kind of depends on what state you're in, but it's usually 2 to 3 documents. It's a durable financial power of attorney, like Lindsay said, and it's a healthcare surrogate or healthcare power of attorney. And sometimes some states combine the living will with that healthcare designation, but sometimes they're 2 separate documents, like they are here in Florida where I'm at. So,
Sure.
um, Lindsay,
And
let's move on because I know this next topic is kind of ties into the wealthy
sure.
about why you still need it even if you're not wealthy, and that's I can just wait for retirement. I'm just going to wait till I'm older. I don't plan on passing away till I'm in my 80s or 90s or even beyond that. So I'm just going to wait and do my estate plan and when I retire. Is that a good idea or a bad idea?
Sure. Well, and I think Andrew, actually, we do need to touch on what is a trust and
Sure.
how much do you need. I think we missed those ones, so we'll circle
Yeah,
back. But
sure.
to go to Andrew's question on, oh, sorry, did you want to go back there?
Yeah, I'll let you go back.
Okay, just because that's a big piece of this too. So what's a revocable living trust? It's a document that says what happens to my assets when I'm incapacitated, how are they managed for my benefit or my family, and then what happens to them when I pass away. And what's wonderful about this is ideally there's no probate court involvement. This is an out of court document. You get to set the stage, you get to call the shots. Who, what, when, where, how is this plan set up at every step? Now, to make sure this works, everything has to be properly titled and have the beneficiaries correct. So if I have my revocable living trust and I call it the Weinberg Living Trust, dated, today's date, August 27th, 2025, my bank account A that I talked about earlier needs to be titled in the name of my trust, and I'm listed as the trustee. Same with my life insurance, the beneficiary on my IRA potentially, and any other assets that I own or control at my death. The goal is to have everything in or payable to that trust, as long as that makes sense with your particular plan. So you speak with an attorney about building that plan and what works. And then the last question, well, how much money do you need to have a trust? I get this question all the time. And I like to explain to clients, it's not really about how much you have. It's about how much you care. It's about what's important to you. Do you want to avoid the probate that we discussed? Do you want to be able to plan for contingencies? Do you want to be able to dictate who, what, when, how? And some of my favorite questions to ask clients are, if you could write a check to each of your kids for $200,000 each, would it make you uncomfortable what they'd do with it? Or if you could protect this inheritance from lawsuits, divorce, bankruptcy, would you want to protect it? And those answers tell me that, yes, this client would prefer a trust versus other methods of distribution.
Yeah, back in when I was working in private practice at a law firm, we did a lot of trusts that set up that had distributions to children staggered. So they got a certain amount at one age, and then maybe 5 or 10 years later, they got some more. They got income in between. And the idea there is, okay, maybe when you're 21, you're not as responsible with money, and if you blow through it, you're still going to get some more when you're 25 or 35 or whatever ages that you pick. So I think that's a good point for sure.
Sure.
Okay, so waiting for retirement. Why is that a myth?
Sure. Well, none of us has a crystal ball, do we? If you do, I'd be interested to speak with you. But life happens. It doesn't wait for retirement. The illness that happens, any injuries, deaths, unfortunately, those things don't happen when we expect them to. They can happen at any time. So while you're healthy, while things are fine in your life, it's a great time to explore. Do I know where all my assets are? Are all my passwords written down, or my memberships or subscriptions? Is all this information somewhere where the people I have put in charge know where it is? What about your household accounts, like your utilities? Any other important papers? Have you pre-made funeral arrangements? If you were going into the hospital tomorrow, would you feel relaxed about all of these things, or would you be in a panic instead of focusing on your health? So these are some other questions on this slide for you to consider. And nobody really enjoys planning for these things, but I'll tell you what, they do enjoy the feeling of relief that happens when you do have these things in place, when you do have that team of advisors on call, when the people that you've named know that you've named them, they understand the plan, or even if they don't have the logistics of that, they at least know who to call, they know who your attorney is. You don't have to tackle it all at once. Set small goals for yourself and accomplish it over time, but make it a goal. Maybe it's by the end of this year, I'm going to get my things in order, or make that your goal for the new year, 2026. Let all those puzzle pieces come together.
Yeah, and that's a great way of describing it, puzzle pieces, because that's kind of what an estate plan really is. It's different puzzle pieces that you're putting together to create the complete plan. And I think that's great that you said you don't have to necessarily do it all at once, because these are some tough decisions to think about, and it can be a little overwhelming, but the key is getting started on it for sure.
That's right.
Okay, our next myth. It's all or nothing. This one's kind of related to charities, where this is American Heart Association hosting this, so we got to talk a little bit about that. So there are some folks that think I can either leave all my assets to charity or I can leave it all to my family, but I can't mix and match that. That's a myth, isn't it?
Definitely. Leaving assets to charity or a gift to charity is a common and thoughtful part of estate planning, and even small gifts can make a meaningful impact. No, it doesn't require significant wealth or necessarily setting up a trust. And gifts to go to can go to charities in many ways. You can do it by a last will and testament, by your revocable living trust. You can even do it by beneficiary designation. And Andrew touched on earlier, and I'm sure you can share the kinds of assets that American Heart Association likes to accept, but leaving taxable assets like retirement accounts can be very beneficial because charity won't have to pay the income tax and neither does your estate. So it's a win-win for everybody in that. I really like to ask clients, would they like to benefit a local chapter of an organization or a national chapter? That's something to think about. Definitely, if you've named charities, evaluate those from year to year. Is the charity name still the same? Has their address changed? Do they still exist? These things change all the time. And a really wonderful idea is to contact the organization and ask them questions and ask for bequest language because I know they offer that.
Yeah, it's great that you brought that up. I was going to include that. I was going to say, one of the great things about the American Heart Association and a lot of charities out there, it's not just us, but we have folks like Gunnar who work with donors all around in various states and areas to help them make their charitable plans a reality. We can help with restrictive language. If you want to restrict a gift a certain way, you can bounce some ideas off us. We can bounce some ideas off you before or while you're talking to your attorney as well. So I think that's a great recommendation.
Real quick, if I could jump in, guys, we have a question that came in, not related specifically to this topic, but the question is, the attendee is ill, they have a trust, the assets are protected from a financial spin down before becoming eligible. So the question is, are the assets protected from a financial spin down before becoming eligible for Medicaid assistance? So probably outside the purview of this presentation, but wanted to throw that out there.
Yeah, well, it sounds like you've worked with your attorney to avoid having to spend down assets to qualify so that you can qualify for government benefits and then you can preserve your estate for your family, your heirs, where you want them to go. And that's certainly one of the options associated with long-term care estate planning.
Yeah, and I would just add, that's one of the kind of trickiest legal areas is Medicaid planning. And that is definitely a situation where you want to talk about your individual situation with your attorney and get really fine-grained advice on that because that's a very tricky area. And it's not something just anybody and their brother can do. So,
That's
all
right.
right, our next myth here is the one and done plan. Is it a myth that once I do my estate plan, I go and visit a great attorney like you, Lindsay, and I have everything set up, my durable power of attorney, my will, my trust, my beneficiary designations, that I can just put them in a drawer and then wait till that day when they're needed?
Sadly, I would not recommend just putting that estate plan in a drawer and never looking at it again. I'm sorry, it's not a check it off the list and I don't have to think about it anymore. You are estate planning through your life, whether you know it or not. And just think about in the last year, have you had any changes with your family or people that you've named as trustees or agents? Have there been any name changes? Did somebody get married or divorced and change their legal name? Was someone unfortunately diagnosed with illness and they're not going to be up to the task of managing your estate anymore? Or are the people that you've named truly capable of managing money and making good financial decisions? So yes, there are all those certainties in life, death, taxes, and change, and the laws change as well. The tax laws change, federal laws change, the state laws change, there's technical law changes. So you can say, oh, I've had no changes in my life, but there could be several things changing around you and around that plan that you're just not aware of. So I definitely encourage, and in my practice, we encourage yearly review and update of our clients' estate plans. And attorneys have all different opinions on that. How many years, every year or every couple of years should you evaluate your plan? It's whatever makes you comfortable. But certainly you want to have that trust and knowing that your plan works the way you expect it to. So it might not be a bad idea to review it consistently.
Yeah, and
Now,
I
the
think,
next, yeah,
go
go
ahead.
ahead.
No, I was just going to say, you may be getting ready to talk about this, but yeah, as you wrote here on this slide, small changes can really be fairly cost effectively changed without, you don't have to redo your entire will or your entire trust, right?
Yes, typically. And if you've, reviewed your plan on a more consistent basis, the idea is that it won't be such a big cost. Now, if it's been like 5 or 10 years since you've reviewed your plan, yeah, your attorney might make you amend and restate it because there have been so many other changes that you're not aware of, or they might suggest that's the way to go. And one other point on here, I typically advise clients against just writing in changes on their documents, but and what we call that is a holographic will or a holographic change. And some states recognize handwritten wills, holographic wills. Some states don't. Missouri is one of those states that don't. But for the states that do, the requirements for those written changes to be valid vary from state to state. So you want to be very, very careful, and it's really easy to fall into the trap of thinking that you made a valid change to your plan that's actually ineffective. So do yourself a favor and call your attorney.
Quick
Yeah, and
question,
I will
Lindsay.
add this from experience on a state settlement on our side. So, we get several hundred estates a year, and most of them go fine. We have no problems. We get our distributions, but inevitably, the handful of ones that we do have a problem with for one reason or another, will contest, whatnot. About half of them either are totally handwritten by individuals, or the individual has tried to make a handwritten change on there, and it causes all kinds of problems. So I will second what Lindsay says about don't just write in changes. Go talk to an attorney about making formal updates.
So we've got a great question specifically pertaining to that, related to terminology. What is a will codicil?
Sure. A codicil is simply an amendment to your will. It's not replacing it, it's adding to it.
It's usually a pretty simple 1 or 2 page document that just says take out lines or section 17 and replace it with this new section 17. So it's a pretty easy type of thing to change. So Lindsay, our next myth here: trusts don't need maintenance. Talk
Sure.
about that a little bit, please.
Sure. So you met with your lawyer and you executed your estate plan. Now what? You go about your daily life, and not knowing it, your plan is living and breathing just as you live and breathe. Like I said, you are estate planning through your life, whether you know it or not. Every time you open that bank account, a new CD, maybe you change jobs and all of your employee benefits have changed, such as life insurance. You perhaps bought a car or you bought a home. Did you name a beneficiary? If you have a trust, did you title it properly? Is all your paperwork organized and accessible? Yes, even the bank account with $5 in it needs to be accounted for. Every single thing that you own. And that surprises a lot of people sometimes. It's really wonderful that if you changed, if you have a financial advisor, that you're working with them on these things too and keeping up with those changes. And if you change financial advisors or institutions, have those account titles changed or have the beneficiary's name changed. Does that institution accept your power of attorney? You're essentially starting over with that financial institutions, and you want to make sure that everything carried over properly as it should have.
Yeah, and I think that's a great point about titling your assets. if assets aren't titled properly, meaning the right designation is on there as who the owner is, whether it's the trust or you individually or you jointly, that can mess up an entire estate plan. I've seen that happen numerous times. So it's not enough to just have the documents. You have to make sure those assets are titled correctly. And again, your attorney and financial advisor can help you with that.
Absolutely. And it's really important to schedule regular time to review and update your plan. Just as you have a checkup with your doctor every year, or just as you review your financial plan with your financial advisor every year, why not review your estate plan and make sure everything's in order?
Right. Okay, so you've convinced me, Lindsay, that I need an attorney to go do it. Can I just go to any attorney though? There's an attorney on every corner, it seems like out here. So
Sure, you could, Andrew, but it's not really something I would recommend. For instance, if someone came to me and asked them to handle a criminal matter or an intellectual property matter, I would say, I'm sorry, I can't help you, but here are some names of, some recommendations or people who I know practice in this area. All attorneys are not the same. We have different practice areas, different levels of experience. Estate planning is definitely its own animal. There are constant changes in the law. There are many levels to it. You want to look for an attorney who focuses their practice in estate planning. And certainly your attorney should be licensed in the state where you're a legal resident. There are some requirements sometimes for different state laws so that your plan is considered valid. So that's a really important piece. And just some things to ask or consider will your attorney help with designing your plan, executing your plan, helping you fund the plan, making sure you have the right asset titles and beneficiary designations? And do they have a process or a method for you to keep it up to date with changes? Do they have experience administering the plans at death? That's a really valuable service as well. Feel free to interview multiple attorneys. Let them know that it's an interview. Look for somebody who values the relationship over the transaction, because then you have someone, an attorney, who's part of your team, especially if they're willing to work with your other advisors and involve everyone in on the conversation. Also, look for an attorney who invites your questions, an attorney who wants you to get it right so that everything flows as it should. I think those are the most important things to look for. And yes, this last point, it does happen. I've seen it happen firsthand. If a non-licensed attorney tries to sell you a trust, let your red flag raise up and run away. That's definitely not the way to go when you're looking into setting up a trust. You want to work with a licensed attorney for sure.
yeah, and I think that's great advice. All of those things are great advice, Lindsay. And it can be kind of tough if you've never done this before to like, well, how do I even find an attorney or get somebody? And I think you can obviously talk to friends of yours or family of yours who have had one done in the past, and then you can do a little investigation on your own on that particular attorney. You can also go to somebody like a Gunner. All of our charitable estate planning directors around the country, although we can't draft wills for you, they can give you 3 or 4 names of an attorney in your area, typically that do estate planning, and that can be a good place to start. I mean, it's obviously up to you to vet them and do all that, but that can be a place to start when you just have no idea how to start.
Absolutely.
Okay, last myth here. Estate planning is complicated and expensive. I mean, all this you've been talking about, Lindsay, this sounds really expensive. I got to be honest. We talked about all kinds of different documents. So is
That's
that a
right.
myth or is that true?
That's right. Well, it certainly is an expense whenever you're going to work with an attorney or work with a doctor or work with a financial advisor. Isn't there a cost to everything? Certainly there is. And in the marketplace, there can be a range of costs for an estate plan, which is why I definitely encourage you to meet with different attorneys and interview them and ask them these questions. And certainly it's a lot of information. Yeah, it feels a little complicated, especially when we're not super familiar with all the pieces of the puzzle, but that's why you go to an advisor who focuses their practice in this area so they can break it down for you and make what seems very complicated much more simple and easy to digest. But I'll
Yeah.
urge you to think, is it more expensive, do you think, to die with a plan or without a plan? To react to an emergency situation or to have a proactive plan put in place? Do you want to have a plan where you get more say in what happens? And think back to those reasons why we may want to avoid probate, avoid those extra fees and costs. Certainly, the advisor that you choose has an impact on this. So, like I said before, look for the value of what you're getting and that it covers all the pieces of the puzzle. Look for an attorney who wants to get to know you, your family, your dynamics. Someone who asks, if you name your children to act together, do they even get along? Let's have them translate, how is this plan going to practically unfold in your life? And look for someone who's going to educate you on your options and let you have the final say in what your plan says. Certainly, looking for somebody who charges fixed fees versus hourly fees can have an impact on your experience. A lot of people avoid asking their attorney questions when they know they're going to get a bill for it. So do yourself a favor and, don't set yourself up for failure if you know you're going to get upset every time you make a phone call and you get a bill for it. So sometimes the fixed fees are really nice for estate planning. And of course, you want a comprehensive plan that covers what happens to assets on disability and death. These things can minimize estate taxes, capital gains taxes, and provide a lot of benefits for you and your beneficiaries. And so, wrapping things up and considering all that we discussed, I hope you all know that you have the power to create your own experience here. And the power really comes from educating yourself and knowing your options so that you can create and maintain the plan that's right for you.
Great. And Lindsay, one question that I get a lot and that people might be thinking out there is, I see all these online tools nowadays where you can create your own will, et cetera. And in fact, the American Heart Association even offers a link to what we call free will. And I think those can be great starting points.
Yeah.
They can help you get your thoughts in order and, be used maybe in an emergency situation, but it really pays off to have an attorney sit down with you and go through all those options, talk about all the ways things can go left or right or go wrong, or and craft a really good and complex plan that will cover all your eventualities. Again, I think that can be a good place to start. And you can even maybe take that online will that you've done to the attorney and say, hey, look at this. Tell me what you think.
Absolutely. I agree. Definitely a great place to start, a great place to get your mind moving and let you think about questions that perhaps you weren't aware of. But I'd certainly take it to an attorney and have the discussion with them and let them lead you down that path.
Great. Well, we have busted 10 myths, and thank you, Lindsay, for all of the commentary that you get. I'm going to turn it back over to Gunnar. Gunnar, why don't you wrap it up for us? Tell us some kind of conclusions that we can take away from today's.
Yeah, thanks, Andy, and thanks, Lindsay. Really great stuff. Really expert advice. So in conclusion, just to wrap up, summarize some of the key points, folks, don't wait. Get started on your estate plan today. It's really important. And like Lindsay mentioned earlier, once you get it done, or at least get it started, it's going to provide a lot of sense of relief for you if it's something that you haven't done so far. Work with a competent attorney who focuses their practice on estate planning law. In addition, an estate plan is a great way for you to support your favorite charities while still making sure that your loved ones are provided for. Make sure you review and update your estate plan regularly based off of life events and things that happen. Those are great times to take a look and look at some updates. And also you want to create a workable estate plan that is the last gift you will leave your loved ones and your last chance to make the world a better place. Um, so yeah, thank you folks, and thank you again, Lindsay and Andy for your advice today. So with that said, we've got a couple extra minutes for some questions. So please take a moment to submit a question if you have any. And I've got a couple here that I can toss over to you, Lindsay and Andrew. Let's see here. Here's a good one that we have. So I want to know if you have a separate will, if you need to have a separate will if you own property in two different states. Do you need to have separate wills for that?
My answer would be no to that question. You can certainly have your estate plan, and you really only want one original will, certainly. But the important thing to be would be that if you have property in other states, you want to make sure it's properly titled or has the right beneficiary so it flows through the plan that you set up.
Yeah, and I'll just add to that, one of the things that Lindsay pointed out, one of the expenses of probate can be if you have real estate in multiple states, because you have to open up a probate potentially in both of those states. However, if you have a trust and the land that you have, no matter what state it's in, is titled in the name of that trust, no probate in that ancillary jurisdiction in that other state where you have to do it. So if you have real property in multiple states, that is a great reason to have a trust and do some estate planning.
Absolutely.
Great, thank you. I think we've got time for maybe another one.
I saw
What
there's a
happens?
question on there. Is it recorded for later? Yes, this
Okay.
presentation is going to be recorded, and there will be a link available, and also the slides will be sent out as well within the next few days. But sorry, Gunnar, go ahead. Didn't mean to cut
Yeah,
you off.
thanks, Andrew. What happens if you don't have a will and you're single?
Sure. So basically, you don't have to have a will or any documents. You can pass away with assets in your own name, having no beneficiary, and they will go through probate. And whatever your state's, it's called intestacy, dying intestate, dying without a will. Those laws that are already written in your state statutes will control where your assets go and who they go to and how. So if you'd rather have a say in what your plan says, it's a good idea to get your estate planning documents done.
Yeah, we used to always say the state you live in has a plan for you, whether you like it or not. But
Exactly.
you can change that plan, and usually if you do die intestate, there's a certain order of relatives that are going to get it. Certainly, you can't give to money doesn't pass to charities or anything like that, but it starts kind of going through your closest relatives and kind of keeps going away and away until you get far. And if you get far enough and there's no relatives, it's going to default to the state that you live in. And most people definitely don't want that to happen.
Right.
Thanks, guys. I think we have time for maybe just one more. Um, what's the general cost of having a will done or perhaps a trust? And this is obviously varies based on where you live and how complex your plan is. But for just curious, a basic will or trust document, what would kind of the cost be?
Mm-hmm. Well, I can really only speak to trust-based plans and the marketplace of where I'm located. So I've seen, trust costs around, maybe around $3,000 I've heard of lately in the marketplace. And a trust-based plan, meaning a trust will, powers of attorney, financial, medical, and some ancillary documents along with that. And certainly I've seen the costs go up from there. And so it just depends on who you're working with and what their fees are. I certainly believe and have experienced that you get what you pay for when it comes to estate planning. So make sure you're considering that. I wouldn't typically look for the cheapest plan because the cost is really a reflection of the time that's going into it. And it's your plan. You want somebody to put in the right amount of time.
Yeah, I would agree with Lindsay that the prices are all over the place. I think if you just did a very simple "I love you" will and you didn't have a power of attorney and you didn't have a healthcare surrogate, you could probably find somebody to do that for I don't know $750, 1,000 maybe. But that's not usually going to be a complete plan. But you're looking in that range, 1,000 to 3,000, I think, depending on how complex and how many documents are going to be brought together. If somebody offers to do it for $250, that's probably too cheap. Now, a codicil to a will, if you've already got a will and you just want to make a little change, or an amendment to a trust and you just want to make a little change, those can be, definitely under $500. Again, depends on the situation and where you're at. If you're in New York, it's going to cost more. If you're in rural Nebraska, it's going to cost a lot less. But, again, that's a great question when you're interviewing attorneys. Ask them how much it's going to cost. You're going to ask that for a lot of other things that you do. So don't be afraid to ask the attorney to do that. And I think I agree. Lindsay said earlier, flat fee is the best way to do estate planning. What you're going to get and how much it's going to cost. And, it's irrelevant how long it takes the attorney to do that. And I would also recommend getting a representation letter from the attorney after you've had that initial meeting with them, outlining exactly what he or she's going to do and exactly how much it's going to cost.
Wonderful. Well, thank you, Lindsay and Andy. Great points. Thanks again. That's all the time we've got. So thank you, Lindsay and Andrew, for sharing your advice and experience. Really great information. So yeah, unfortunately, that's all the time we have. If we didn't get to your question, someone from our team will follow up with you directly. And also as a thank you for joining us today, everyone, we have some fantastic resources for you to help you with your next steps in planning. In addition to materials about specific topics like charitable trusts and beneficiary designations, we're pleased to offer what's called the Heart of Your Legacy, which is a personal estate planning workbook. You can request these complimentary resources by visiting our website at www.heart.org/plan. And as we mentioned earlier, for those with less complex estates, the association's partnered with Free Will that provides an online, simple, free, and easy way to create a will document. Again, encourage you, if you use that source, to consult an estate planning attorney to review that. And you can simply scan the QR code on the screen to begin your free will process online. We'll include links to access these resources in a follow-up email, so be sure to keep an eye out for that. So again, on behalf of the American Heart Association, thank you so much for joining us today, and especially want to thank Lindsay and Andrew for their presentations. We encourage you to contact us at any time if you have any questions. We have staff throughout the country like myself that are here to support you. Email us, give us a call, visit our website to find a dedicated charitable planning advisor in your area. And lastly, we want to conclude for today. As we conclude, please provide our team with your feedback on today's presentation by completing our short survey. Really helpful information for us to help improve our programming for you. The survey will pop up in your browser immediately following the webinar. And thank you again for joining, and goodbye, everybody.
Thanks, everyone.